All right, and take it away.
Good evening, I'm Renee from Tri-County Home Health. We are a home care agency here in the Tri-County area, Chester, Montgomery, and Berks. We have the privilege of working with Curran Law, and I just wanted to introduce Sean for tonight's presentation. It's going to be a great presentation. Enjoy.
Thank you, Renee. So welcome to our estate and elder law webinar. And if I can figure out how to do this wand thing, which I'm having trouble with.
Make sure you point it at the laptop.
It's not working. Is it blue? Can't have a Zoom without technical difficulties, right?
That's right.
So I'll go on to my introduction. So basically, my primary role is a dad and a husband. My wife and I both grew up in Pennsylvania. She's from Montgomery County, Pottstown. I'm from Schuylkill County. And we have 4 children. We live in Wyomissing, Pennsylvania. I'm the founder of Curran Estate and Elder Law. Oh, there you go. And we practice exclusively estate and elder law, as the name implies. Go figure, right? But we have 2 attorneys, myself and Rose Kennedy, 6 team members. One of our team members is an elder care coordinator, and that makes us unique. The firm, it's a life care planning firm. It's a different practice model for estate and elder law firms. We get into the kind of the social aspects of aging, beyond just the legal documentation and the qualification for benefits. We get into care coordination, selection of agencies, selection of communities, selection of skilled nursing facilities, and so forth. We deal with family education, about the process they're going through, healthcare and financial decision making, of course, benefits qualification, care advocacy. If we have someone who needs an advocate who doesn't have a family necessarily, we're that advocate for them, and of course we're dealing with crisis management as well. It's a very holistic form of practice, much more satisfying. We deliver a great service to our clients. We help them out in very, very serious, emotionally charged series of transitions, from the hospital discharge to a facility rehab and so forth. We're closely involved. Okay. Going back the other way. So here's our agenda. I'm going to talk about the important documents that you should have in your estate plan. We're going to talk about how assets are transferred after death. This is really going to give you insight into how we put together estate plans in the first place and how we administer estate plans after the death of the individual. We're going to talk about probate. Probate is the process of administering a decedent's estate. And it's coupled with the perils of gifting, because they are connected, and I'll show you how they're connected and what you have to be aware of before you do some of the things to avoid probate that people get themselves into hot water. I'm going to talk briefly about long-term care costs. Everyone knows they're surging, skyrocketing, out of control. And the long-term care statistics. As we're aging population, of course, more and more of us are needing care. I'm going to talk then about leveraging our assets or military service. If any of you listeners are veterans or spouses of veterans, we thank you very much for your service. And I'm going to talk a little bit about a program, a pension benefit that you may be entitled to. And I'll go over the service requirements and the economic benefits of that program. I'm going to talk about Medicaid qualification. How do we qualify for Medicaid financially and physically? I'm going to talk in between here a little bit about nursing home admission. There's 2 ways to actually get into a loved one into a nursing home. And then finally, we're going to talk about how we protect assets or don't go broke in a nursing home. So, important documents you should have. Without question, the number one, it's up there for a reason, most important document while you are alive is the durable financial power of attorney. A financial power of attorney is a document where a principal, an individual, authorizes an agent to make decisions on their own behalf, on their behalf. The agent doesn't need to ask for permission. The principal can revoke that authority if the agent is acting in a rogue behavior, but the agent has contract binding authority upon the principal. So typically, financial matters, banking, of course, selling real estate, investing in different assets, changing beneficiary designations, and so forth. Now, a financial power of attorney is the preferred alternative to guardianship, and this is legislatively preferred. A guardianship is a situation where we have an incapacitated loved one, right, without a power of attorney. We have to go to court. We have to establish medical testimony that the individual is incapacitated, essentially cannot manage their own affairs. The judge, it's an open courtroom session. The petitioner, who's typically the proposed guardian, takes the stand, discusses their relationship. It's an expensive process in Berks County, which I'm more familiar with. It takes about 6 to 7 weeks to get, by the time you file the petition, by the time you get a hearing with the court. You have the medical testimony, it's expensive. The agent has to report on an annual basis with an accounting to the court about the individual's assets. And importantly, in a guardianship environment, we cannot protect assets nearly as well as we can protect them in the environment of a financial power of attorney. So this is a very inexpensive document to get, and not all powers of attorney are equal. They should have hot powers when we're dealing with elderly clients. Hot powers are powers essentially to change your estate plan, which sounds radical, but under the right circumstances, it's very powerful. These powers are beyond what we call the statutory powers. Two of them I want to mention is unlimited gifting. Now, the principal authorizes the agent to gift his assets. We want to make that unlimited gifting because that is a very, 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 very important way we protect assets, and we'll talk about that in the last slide. But unlimited gifting, and then the power to change beneficiary designations as well. So if the principal has a 401k with the designation going to his wife who's in the nursing home, we don't want that asset going to the wife in the nursing home necessarily. We want to redirect that and power to change that designation. That's another area where we can protect assets if we need to. It is a high area of concern for elder abuse. This is typically where we have a situation where we have a single agent involved and an incapacitated principal. So the agent really has a fertile environment to misbehave. If we have that situation, we're always recommending co-agents with independent authority to act. We do not require co-agents to have unanimity, mainly because banks are rejecting that setup. They will not accept a power of attorney where there's unanimity. They don't want to babysit. They will force one of the agents to resign, so they're dealing with one agent. They do not want to have unanimity. They are very much okay with independent authority to act, but they're not going to they're not in the babysitting business. So that's the general financial power of attorney. Make sure you get one by somebody who knows what they're doing, because not all of them are created equally. Do not have limited gifting. It's a buzzkill when we're trying to protect assets. And then we have the healthcare power of attorney and separately living will. The healthcare power of attorney, like the financial power of attorney, authorizes an agent to make decisions on treatment, medication, access to medical records, the authority to admit and transfer into various facilities, and the authority to request from a physician a do not resuscitate order. Okay, this is for what we call positive treatment, which really means that the individual is going to likely recover, but is incapacitated and cannot make decisions at the moment. So we invoke the healthcare power of attorney. The living will is a little bit different. It is more of an end-stage directive. Now, a physician has to determine that the individual is permanently comatose, vegetative, non-responsive, not likely to recover, essentially terminally ill. And these directives are an election by the individual, the principal who's now incapacitated, whether they want life-sustaining measures taken or not. Some do, some don't. Do you want, kidney dialysis or CPR or any antibiotics? You can fine-tune it however you want, but it is your end-stage directive. Typically, we have an agent on the living will only to invoke the removal, if that's so the desire of the principal, and the timing, so that the family has time to get the family together, and then they say the agent can authorize when to remove the life-sustaining measures. And then finally, you've all heard of this one, the biggie, everyone knows, but this is after death, of course. The last will and testament names your beneficiaries. Beneficiaries are the individuals, most likely your family or friends, close friends, who are to receive certain portions of your estate, okay? They're your beneficiaries. And your executors. Your executors are the individuals who are authorized to manage the administration of your estate after you die. They're the CEO of your estate until all your debts are paid off and taxes paid and beneficiaries are distributed their assets, and then their job is done. So when we pass away, the durable financial power of attorney is null and void. It has no further bearing on anything. We look to the will, to the executors for the authority to administer the individual's estate. Individually assets go through your will, and we'll talk more about this next slide. And we could include what's called a testamentary trust. Let me tell you what a trust is. A trust is a contract between three parties. The grantor, the individual who's creating the trust and who's got the assets to contribute to the trust. The trustee who manages the trust has the authority, like the executor of an estate, very similar, but this is in the trust environment. So we have a trustee who has the authority to manage the trust. And then of course we have a trust beneficiary, similar to the estate, but it's the beneficiary of the trust-owned assets, okay? And a trust, of course, is a legal entity. It can own assets, it can pay taxes, it can hire individuals to do work. So a trust is very much of a legal entity where we could put assets into, hold assets, and so forth. A testamentary trust is a trust that is created in your last will and testament, but it's not funded, meaning we don't transfer the assets into the trust until the individual dies, the estate goes through probate, and then the assets are transferred into the trust. Then why do we use a testamentary trust? If we have a disabled beneficiary who's on benefits program, we don't want to give them a slug of money that would terminate their benefits. This is like a third-party special needs trust. The assets are there for that beneficiary's benefit, but it will not disrupt their government benefits. If we have an heir with a troubled marriage, right? We don't want that marriage to break up and fight over the bequest that we just left one of the married couple. If we have heirs with creditor problems or heirs with addictions, okay, they can't manage their own affairs, they're never able to hold down a job, but we want those monies to be there for that beneficiary. We put it in a trust. We have a separate trustee acting as a filter of those monies for the benefit of that beneficiary, because they can't manage it on their own. Very powerful. And finally, we have use in a spousal environment. So we do these what's called Medicaid wills. It's a very powerful technique that we use where we can limit the exposure of assets to Medicaid in certain circumstances by 2/3, meaning we're protecting 2/3 of the estate of the couple, where the surviving spouse has full access to 1/3 of the assets and to the 2/3 through a trustee. So the surviving spouse still has full access to the monies, but the 2/3 is protected if that surviving spouse needs to go to a nursing home. Very, very powerful technique, okay? Asset transfers after death. We have to know the type of asset and how it's owned. So first we have jointly titled assets. There's a couple different joint ownerships of assets, but I'm going to talk about survivorship joint ownership. And a survivorship joint ownership is like a married couple buys a home, both their names are on the deed. When the first spouse passes away, their interest in that home automatically transfers to the surviving spouse without any documentation or filing of any deed whatsoever. It happens by what's called operation of law, instantaneously upon the last breath of the first spouse to pass away. Same with bank accounts. Okay, if we put joint accounts together with husband and wife or a parent-child, the individual who passes first, their shares automatically pass to the surviving joint owner. They avoid probate. They don't go through the estate administration that we're going to talk about next slide. Then we have beneficiary designated assets. Assets like your IRA, your 401k, your life insurance, annuities, and securities with the designation of payable on death, transfer on death, or in trust for. And these go direct to the named beneficiary on the account from the administrator of those assets. Okay, with a claim form and a death certificate to the administrator of those assets, they get retitled in the name of the beneficiary automatically. No probate. We avoid probate, okay, for those types of assets. So we put an estate plan together. We're dealing with joint owned property, individually owned property, and beneficiary designated assets, those three classifications. So assets that actually pass through your last will and testament are again owned individually at the time of death by the decedent. Just like the marital home, we killed off the first spouse, interest transferred to the surviving spouse. That surviving spouse now owns that home individually. Upon the death of that surviving spouse, that house will most likely go through probate. Of course, it goes to the beneficiaries in the will, and it must go through probate, okay? So those are the kind of the general overview of the asset transfer. It's very important to understand the kind of the inner workings of how estate plans work. And everything, this is a very general statement, but it's sufficient for discussion tonight. Everything except life insurance death benefit proceeds are subject to Pennsylvania inheritance tax. This is a state of Pennsylvania tax. This is not a federal United States government tax. This is a Pennsylvania Department of Revenue tax on the inheritance you receive and the value of the inheritance you receive. And it depends on the degree of relationship to the decedent that will determine your rate of tax. So 0% for spouses and charities, okay? 4.5% for lineal descendants. Parents, grandparents, which happens very rarely as a beneficiary, and of course children and grandchildren pay 4.5%. Additionally, step children are in this classification. Step grandchildren are not. They are in the last category, the 15% category. 12% for siblings. If you leave monies to your siblings, they pay 12% of the value of the bequest, and all others are paid 15%. That's important to understand. There is that tax. It's very difficult to bypass this tax. There is a type of trust that we can do, that the assets have to be in the trust for a year that would avoid that tax. There's some downsides to that. And again, life insurance death benefit proceeds are tax exempt. So probate and the perils of gifting. Again, probate is a court-supervised process to clear the decedent's assets of creditors' claims. It's a cleansing process. We want to make sure there are no claims upon those assets when we transfer them to the beneficiaries. So it's a cleansing process. And what does that involve? It's a public process, requires the executor to swear in, newspaper publication. I'm sure all of you have seen newspaper publications of open probates. What is that for? That is a notice to creditors that you have 1 year to make a claim against the estate or your claims will forever be barred. That's the cleansing process. We have to give notice to beneficiaries. We have to pay the inheritance tax, typically within 9 months. There's an opportunity to get a 5% discount on that tax if you pay within 3 months. So that's probate. And people try to short circuit probate because they think probate is onerous and difficult and expensive and so on and so forth. I will tell you, in some states that is true. Our neighboring states, in fact, New Jersey and New York, have pretty onerous probate processes. California and Florida are pretty bad. Pennsylvania is one of the more amicable states to go through probate. And people bend over backwards sometimes to avoid it. They add their child's name to a house. If we have a widow situation, oh, I'm going to put my son's name or my daughter's name on the house. We'll avoid probate. Great, because they got that news from the hairdresser or the bank teller or whoever thinks they know what's going on. They can say, just put your son's name or your daughter's name on the account. Or bank accounts is another famous one. They put their child's names on bank accounts so they can write checks. That's what the power of attorney is for, so they can write checks on your account, your individually owned account. Because if we gift assets, and that's a gift, by the way, by adding the name of a child onto an asset is a gift. Gifted assets are subject to your donee. Your donee, of course, is the person you're adding, the person you're giving the gift to, your son, your daughter, your donee's life circumstances, divorce, creditors, addictions. Okay, so if we have a closet, problem child that we don't know about, we add their name onto the house, the creditors see pop up and they see, oh, he's got a house or she's got a house, we're gonna foreclose on that house. So that's a devastating situation. If you gift assets within 5 years of needing nursing home, you could be ineligible for Medicaid for a period of months. It depends on the value of the gift. That will determine your length of your penalty. They're not going to come in and reach in and take your assets from you, but the consequence is you'll have to pay the private pay rate for nursing home before you can get on Medicaid. Okay, not good. Finally, if a donee predeceases you, so if your daughter predeceases you and you just added her to the home, you get the house back, like we talked about joint survivorship ownership, you get the house back automatically, but you created a tax liability for yourself. 4.5% tax liability. So be very careful about taking the advice of a hairdresser or a bank teller or whoever else, the butcher, candlestick maker, telling you to do this stuff to avoid probate. It is not without risks. Okay. So let's talk quickly about some care costs. We have community-based care provided in the home. This is a broad range, right? These are just numbers kind of thrown up there. It could be lower than $1,500 a month. It could be higher probably than $20,000 a month. But this is care aids coming into the home. It's wonderful, perfect for a couple hours a week or a day or so, an hour or so a day, or 2 hours if you can get somebody to do it. Wonderful on the low end. It gets very costly and expensive on the high end of care needs. And one thing I want to tell you is, I know a lot of people pay under the table to the friend or the neighbor or the cousin or whoever's looking after their loved one with cash and so forth, and I'm not going to criticize that, but the higher volume of care needs and therefore the higher volume of money going back and forth, you want to make sure you document. My advice is to go through an agency, right? It's going to be a little bit more expensive, but when you get to this nursing home phase of the continuum, they're going to ask what these cash withdrawals are all about, and you don't want them to be misconstrued as gifts and a penalty. Then we have facility-based care. Personal care is lumped in, by naming conventions with assisted living. There's a distinction between those two, but I just kind of lumped them together to presentation purposes. They can start out as low as $3,000 a month, typically up to $7,500, roughly depending on the region you're in, probably down closer to Philadelphia, it might be a little bit more than that. And then we have memory care floors, which are locked units, locked floors typically, or portions of floors to prevent wandering, a higher number of care aids per patient for the activity, keeping them active, more stimulated. That can go from $7,500 a month to $9,000 per month. All these costs that I've just mentioned are private pay, meaning typically there's no benefit out there, government benefit out there that will help you pay that. So that's coming from your income and your savings to do that, which is very expensive. And then of course we have the highest care level, which is the skilled nursing care. That's typically $9,000. It's now really $14,000.
15 even.
15 even. Yeah, I've got to update this slide. They've gone up so fast. I keep saying that when I do these presentations, I'm going to update the slide, but it's staggering. Like, that's the private pay rate, $15,000. Medicaid reimbursement rate to a facility is about half that, $7,500 or so. So it's a big difference when you're dealing with a skilled nursing facility that they want those private pay customers. And a skilled nursing facility most often has a dual identity. There's rehab classification being paid by Medicare for a certain period of time, and they get the higher private pay rate from Medicare. And then there's a long-term care classification, which typically is on Medicaid. But not always. You can have people privately paying on the high level there as well. Percentage of individuals, so if you've reached 65 years old, the percentage likelihood that you need some form of long-term care that we just discussed, 79% of women, 58% of men. So this only applies to people who've reached 65 years old, okay? Oh, I jumped over one. So, percentage of individuals over 65 that will need skilled nursing care, not just long-term care, skilled nursing care, 58% of women, 44% of men. And this includes the rehab, discharge to a hospital rehab for 2 weeks and back home. So these are staggering numbers. And it's only going to get worse with our demographic aging population. So this is where we talk a little bit about leveraging your assets with your military service. Again, thank you for your service. If we have any veterans or spouses of veterans listening in, this is what we've referred to as a Veterans Aid and Attendance Pension Benefit. 90 days of active duty, not reserves, active duty. 1 day of which, of that 90 days, during a declared state of war. Does not have to be in country of conflict. It could be stateside to serve that 1 day during war. You cannot have had a dishonorable discharge. Your non-reimbursed medical expenses, which essentially is care, like most often Medicare will reimburse all your medical expenses, so your non-reimbursed medical expenses, think care expenses, should exceed your income to get the full pension benefit. Now, a personal care facility and assisted living facility, they are classified as a medical expense and they're non-reimbursed. So typically we have the flurry of applications for this benefit when we have a transition to one of these communities, these facilities, because the monthly pay automatically, typically exceeds their income. They qualify for that criteria. There's a net worth limit of $149,000, not including your home. So if you're receiving care in the home, they will discard the home as far as your net worth calculation. But I've had clients who are on this benefit, having care at home, they sell their home, and all of a sudden they're up above the net worth limit, and they have to be removed from the program until they spend down again and they can get back on. Approximately $2,200 for the vet, $1,100 for the spouse. And again, that is, I'm stuck again, I think. Oh. Your battery is not running low.
Battery on the laptop?
It doesn't pop up, so your battery's running low. So let's talk about Medicaid and how it works. So Medicaid pays for your skilled nursing care expense. Waiver is Medicaid qualification care at home, okay? Now, typically, the waiver, at-home waiver is custodial care level. So if you're diabetic and you need insulin shots, they will not help you with those shots. It's custodial. And there's a limit, typically, of about 8 hours a day, which is what I've kind of, the max I've been really hearing about. There's not a 24/7 care. If you need care beyond 8 hours a day, you are really left to go into a facility. And the, let me see here. Hold on, people. Okay. So the recipient's income typically goes to the nursing home when we have a Medicaid situation, except $45 a month, which is called a personal needs allowance, which is not much, I know, everyone scoffs at that. It's typically for television or incidentals or hair cutting or gifts for your grandchildren and so forth. Health insurance, Medicare premiums are taken off your income. And if we have a breadwinning spouse in the nursing home, there is a formula to shift some of that income, not all of it necessarily, but some of it back to the community spouse, the healthy spouse.
Presentation disappeared.
I think there's a dialog box that's preventing that from showing up. Right. You could actually keep it on this slide.
People aren't seeing
Okay.
it.
So let's talk about Medicaid eligibility. We have medically eligible and financially eligible criteria. The medically eligible is you need assistance with what we call activities of daily living. Bathing, dressing, eating, transferring from a bed to a chair, walking, grooming, taking medications. Those are called activities of daily living. If you need assistance with 3 or more of those, you most likely will be approved for medical eligibility. Our experience is that it's fairly easy to get medical eligibility. It's not a fight with Office of Aging to do that. They come out and assess you. And financially, you have to have less than $2,400, and in some cases, depending on your income, you may keep up to $8,000. So either $2,400 or $8,000 is your max limit.
Is that per month?
That's assets in the bank, not income. It's just assets. But you're only allowed to have up to $2,400 of assets to receive this benefit. So let me talk a little bit about nursing home admission. There are 2 ways we get into the nursing home. One is through a hospital discharge. So we're in the hospital, broken hip, urinary tract infection, dehydration, whatever the cause is, we get discharged to a nursing home. Remember I talked about the dual identity. As a rehab, you're classified as rehab, and Medicare will pay for that care, that rehabilitation. The rule of thumb is 20 days, up to 100 days, depending on a bunch of criteria, and most importantly, which is that you're progressing in your rehabilitation, okay? And if you come into a skilled facility through the hospital discharge, you may get a call on a Monday because they always, actually on a Friday, they always terminate your Medicare coverage and say you're no longer rehabilitating. You can plan on coming to get your loved one on Monday. Pick them up on Monday, he's ready for discharge. And that puts a lot of stress on families. They may not know what's going on. They're waiting and seeing how their loved one does with rehab. They're not sure they can handle it. They're not obligated to pick their loved one up, right? Legally, the skilled facility cannot discharge that loved one into an unsafe environment. So all the family has to say is, we don't have a safe environment to take mom or dad, you're gonna have to keep them. The nursing home will immediately change their tone and say, okay, but you do know that your loved one's on private pay, the $15,000 per month. You're no longer on Medicare. Now there is a process where you can appeal Medicare coverage, and we've had clients be successful, maybe a week, maybe a couple days. It's not a huge amount of time, but it gets a breather. You know, it gives the family a little bit of a breather to make their next move. It's an important opportunity from the hospital discharge to do this, especially if you think your loved one may not come out, even though they're going to rehab. They may be long-term care patients. And this is one of the aspects where our life care planning really comes into play here, because if we have a client who's in the hospital knowingly going to be discharged, we get involved in that discharge. We get involved in the site selection, especially if we know it's going to be a long-term care situation, because the last thing we want is one of our clients discharged to a rehab facility that is not desirable. Because if they have to stay in that facility, they don't want to be in the wrong facility. We all know what that means. And there are good ones, and there are not so good ones. And we don't want to be in a not so good one. Additionally, if the nursing home says, we can help you with your Medicaid application, we've got caseworkers here on staff, we can handle the application, no problem, they will have you spend down to statutory limitations. Now in the case of a married couple, we have both spouses, and then we have a healthy spouse. Statutory limits are, there's an exemption of about $150,000 of assets that the healthy spouse can keep. They can keep their IRA, the healthy spouse can keep their IRA, they can keep a car, they can keep a house, they can have a prepaid burial. That's pretty much the statutory limits. Okay, there's a whole lot more assets involved potentially that they will have you pay $15,000 a month regularly until you spend down to that level of statutory limits. We, although sensitive to the nursing home's desire to have private pay for several months, we satisfy that. But beyond that, there's a cutoff. We can protect above that cutoff, that we get them private pay monies, satisfy them, that it's important for them to have that revenue. We understand that. We respect that. But we can protect more than the nursing home can. So be cautious if you have assets to protect and you're in that situation where the nursing home says, hey, you don't need to get a lawyer, we can protect your assets. Know that it's going to cost you a whole lot of money, a whole lot of money. Okay. Then we have the admission by financial qualification, where it's just, we're not doing discharge from hospital, we're just saying it's time for mom or dad to go to a nursing home. And we knock on the door of the nursing home, bags packed, and they say, oh, very nice to meet you, here's an application. Why don't you take that home, we can't take you right now, fill out your application, and page 3 has all the financial disclosures that we need you to make. And we'll review that application, and we'll get back to you. They have their weekly meetings on Thursday or Friday, and they determine if there's a bed available or not, right? The more private pay you can make, the more available the bed's going to be, which is understandable. It's a business. I'm not critical of that, but that's how it works, okay? The important thing to remember is that that's a tougher, more difficult route to get into the nursing home. And we help our clients with that financial qualification aspect to get into the nursing home. Now, now we're down to the final slide. We're having some technical
Do
difficulties.
advanced slides.
Could you please what?
Advanced slides.
Right, well, actually, there was no slide, I was ad-libbing there, because there's no slide, but I'm ready to advance, and I'm not able to advance at this point. So the last slide, I know it by heart, is about don't go broke in a nursing home, okay? And we can save assets no matter what, right? I should have an asterisk on that, after that exclamation point, and that asterisk would read at the bottom of the page, so long as you have a good power of attorney with unlimited gifting. I want to circle back to that because that's what I said, we're going to talk about that. It's a very powerful aspect of asset protection. But first, let me talk about two different kind of macro ways we protect assets. We do pre-planning, right? Pre-planning is when you're still healthy and want to have assets to protect that you're not necessarily relying on for your lifestyle, and you want to protect those assets for your family, not your spouse. This is your children and grandchildren. This is legacy planning, okay? Spousal, we don't need to really go through this necessarily. We need 5 years of projected good health, right? Because we're going to do a transfer into a trust, an irrevocable trust that we have to get through 5 years, because when we apply for Medicaid, they look back 5 years for any of these type of transfers. That's going to cause a penalty. So we have to have a long enough runway that we're going to stay out of the nursing home for at least 5 years. So it's not, doesn't fit every situation. You got to have money. You got to have, you know, legacy mindset for your family, and you got to have 5 years of projected good health. So we use an irrevocable trust. There's two types that we use. One for real estate that preserves the capital gains benefits and step up in basis. We can preserve that and still have an irrevocable trust. And the other type, if we just have securities, we use for inheritance tax avoidance. So we can use that type of trust. It also has the benefit of protecting the assets after 5 years. We can save 100% of the assets in the trust, assuming they've been in there for 5 years, and of course gets both spouses on the same page. I have a lot of clients that come in, and one of them does the finances, the other doesn't, so it's a great meeting of the minds, and a lot of people like that. That's pre-planning. It's great, very effective if the circumstances present themselves. Then we have the crisis planning. So crisis planning, I like to say, is like a kaleidoscope. When you look through a kaleidoscope, you see a picture. But you change the circumstances, change the dial, you see a different picture. It's very fluid, it's very dynamic, and it depends on the circumstances of what we can do at the moment. So if we have a healthy spouse in the mix, we're gonna save about 100% of the assets. Again, we're gonna pay the nursing home a couple months of private pay, like I talked about, but we're gonna save 100% of the assets if we have a healthy spouse. This, again, is beyond what the nursing home can do if they're handling their Medicaid, their application. And of course, this is when crisis planning is when you currently need nursing home care and you haven't done anything. There's no pre-planning and you're kind of just saying, what do I do? How do I do this? And if you're single individual, divorced, never married, widowed, we can still save about half the assets. Even if the individual's in the nursing home, privately paying, we can save half the assets. Again, if they have capacity, we can save half the assets. If they don't have capacity, we need that power of attorney with the unlimited gifting, because that's how we do it. We do a gift penalty. We gift assets invoking a penalty. 50% of the assets we gift, 50% of the assets we hold back to pay through the penalty. The net result is we save about half the assets. So this is really the high-level overview at the end of our presentation, and I'm going to open it up to
You did have some questions on
questions.
Neil, did Sean answer your question that you put in the chat? Neil, you still with us?
Mm-hmm. So while he's trying to get Neil, by listening to this webinar, just call our office 610-406-5377. If you want to make an appointment, say you attended the webinar at the Phoenixville Library, and we'll give you a free 1-hour consultation. I listen to your situation, I go over your assets, I figure out what type of asset they are, I can tell you what we can do. I'll give you a price fix. We do flat rate pricing. We don't do hourly. You'll never get an invoice for hourly fees. It's an all-in cost, and we do it from start to finish. There's nothing left on the table other than recording fees, which are $60 in Berks County, and they're modest here, I'm sure, and notary fees, which are typically $15 to $20. But that's it. That's the only other areas. And then we like to maintain and keep in touch with our clients into the future. So.
Neil, I see you up there. Do you still have a question?
Yeah, can you hear me?
Yep,
Yes.
we can.
Okay, my question was back in the PA, the state tax slide.
Yeah.
Charitable gifts, aren't charitable gifts tax exempt in PA?
Yeah, sure. What I said, the classification of 0% is spouses and charities.
Oh, okay.
Yep.
Anyone else on Zoom or in the room?
So,
Yes.
Sean, the other question I had would be, your position for long-term care, you think that long-term care policies are valuable for?
So that's a great question, Neil. Long-term care policies, are they valuable? So we had the original long-term care policies back in the day, which is what we call traditional policies. Some of the early ones were great.
Right.
They were awesome. But as time went on, they got diluted and they got not so great. And those policies are subject to change by the insurance company that has issued them. So oftentimes people with those policies may get a letter saying, hey, we're going to either reduce your benefit amount or we're going to, increase your premium. Take your pick. So there's been a bad taste of those policies because of that. There's a kind of an emerging new type of policy. It's called a hybrid policy, where it's actually based on either an annuity or a life insurance platform, right? So with living benefits, right? So you can take that death benefit in the life insurance policy and use it during your life for long-term care. And there's some creative things we're doing with retirement accounts, actually, to fund those policies. They're better than the traditional ones if you're going to buy anything, because if you never even draw any benefits from that policy for care, you still have the death benefit, right? So you're never out, you're never losing. Like, unlike the traditional policy, it's pay as you go, pay or like a homeowner's policy. You keep paying. If you never make a claim, you're out all those premiums. So the only thing I would say about long-term care policies, people have a tend to over-subscribe to them if they go into it. And they have to keep in mind that typically it's the care from a home, care aids, personal care, or assisted living. That's it. You don't want to pay for care for skilled nursing because of Medicaid. I frankly have been seeing a lot less policies in my experience, but I know they're still being sold and people still have a value to them. But yes.
Yeah, question from the chat.
She has a question first.
Oh,
I can
sorry.
wait, I can wait.
Go ahead.
Oh, you sure? Okay. If the estate of the individual is not in Pennsylvania, does Pennsylvania expect payment of an inheritance tax? The recipient,
Great question.
recipient
Great.
lives in Pennsylvania.
Great question. Yes, you will be paying estate tax. Especially, yes, you will. It's a tax, right? No one likes to pay it. Any other questions?
Go ahead, Nadine.
Yes.
I have 5,000 questions. I'll try to summarize. I work in a nursing home in activities. Before I was receptionist, now I'm in the activities part. We have about 72 residents. In order to keep, and I'd rather not name the facility, in order to keep the census up, now we're starting to take people that are in the process of rehabilitation. I've just seen a lot of horror stories. Thank you for all that you're presenting. I'm real estate licensed, insurance licensed. 35 years ago, I married a gentleman who had his own insurance investment firm. I came from Western Pennsylvania up to here, not knowing, and it's okay, it happened. 4 years later, he dies in his sleep from diabetes. To summarize, I won't tell you the horrors that I went through because this was his second marriage. This was my first marriage. It took 4.5 years to settle the estate. The children from his first marriage tried to sue me, and they said, and there's understandings of wills, but they tried to accuse me that I forged a will. We went through an attorney. Of the root of the cause was they said that the children were supposed to get the residual of the estate. So I interviewed 5 attorneys before I finally settled on one that would represent me with these nasty children. So above all, do your homework. I love your presentation, but sometimes you have to compare it to other attorneys. And then with a look back of 5 years, it's nice to say, at present, your loved one or whatever is healthy. But if something changes, there's so many caveats, so many situations that can change. But I see day to day that we're trying to bring in more rehab situations from other hospitals. And it's a nightmare to see a little bit of what you explained. I personally was able to get in one of the better long-term care policies. I got that when I was, how old? 53 and a half. Now I'm 74 years old. Ladies and gentlemen, it took me 3 years to convince myself, after my husband's death when I was 47, I said, why should I get long-term care insurance? I finally decided to get it. I've been paying on it I've been paying on it for all those years. To summarize, if I can, somehow, I have 0-day elimination period. However, the long-term care insurance policy is only good for 3 years. Right. So much has changed. And I honor what you're saying. There's now a new hybrid, and I'm becoming aware of that. But it's hard to have a clear vision. So many nuances can happen.
Yes.
And it's true, whenever you get into a nursing home, they give you $45 to pay for what you need in the way of yummies.
Right.
Absolutely. It's just, you have to do your homework.
Yeah.
They were trying to sue me, sir, so I had to interview. And another foolish thing I didn't know what to do. When my husband died, he had some debts. I had like $86,000 coming to me. Over half of that went to pay off his debts. I thought I had to pay off his debts for my inheritance. After I ran into this, I realized that I did not have to pay his debts out of my inheritance. So life is full of changes.
Life is full of changes.
Life is, sometimes you go through bitter things, but thank you. Do your homework, like you're saying, all this up front. It's not as easy as you're explaining it, but you explained it easily enough to caution us.
Yeah, I'm really just trying to issue spot. A lot of my presentation is like what issues to look out for, certainly. And the takeaways, to your point, what I'm trying to say is, get a good attorney, an elder law attorney who knows what they're talking about. Get that power of attorney with the unlimited gifting. If you have an elder couple, you should have Medicaid wills with the testamentary, especially as trust for each other. Very powerful, especially if you have a large IRA, because that's an individually owned asset, and that's gonna, that can go right into that trust under the right circumstances and protect it. There's a lot of things you could do on the upfront and on the back end, like you were experiencing those unfortunate events. If it's done properly on the upfront, the back end goes a lot smoother.
Is it true that, or what is the value of having life insurance? It is not taxed, because I haven't practiced for a long time.
So life insurance death benefit proceeds are not subject to Pennsylvania inheritance tax. So they're not taxed. So.
Anyone else on Zoom with a question?
Somebody did have a question.
Haven't seen anything in the chat in a while.
I had one more question.
Yeah.
You didn't cover this, John, but with this Cure Act 1.0, the switching of
Yeah.
the
Stretch.
eliminating the inherited IRA as kind of a vehicle to pass generations.
Yeah.
Do you offer services around, kind of IRA to Roth conversions and that?
Well, I mean, that's really more of a financial advisor bailiwick, to be honest with
Okay.
you. I do get involved with IRAs from an asset protection perspective, but not from a kind of a choice of type of IRA. And funding it, of course, your financial advisor would hold the funds and he would give you advice on that, and I wouldn't step on his toes on that. But I mean, if you wanted to ask about how to protect it, I can talk to you about that.
Gotcha. Okay, thank you.
Yep.
All right. Last call for questions.
Things can change
one.
so
Okay.
quickly. Things can change so quickly. You can think that you have a plan, but there's so many nuances.
Yep.
I won't say any more, thank you.
Yep.
Go ahead, Marina.
Oh, thank you. I was wondering if you had anything to add about annuities.
So annuities, yeah, annuities. Annuities have a very high commission rate from the selling person, the agent who's trying to sell the annuity. Okay, I think it's 6%, could be up to 8%. Annuities have one benefit, compelling benefit. They have, if a policy has lifetime income guarantees, meaning that annuities have two different phases. They have an accumulation phase where they're just growing tax deferred, essentially like an IRA, but it's not an IRA. And then you can flip the switch and say, I want to annuitize it. Annuitization means that you're reducing that account balance to a series of monthly payments. Okay, when you annuitize it, especially an IRA annuity, the benefit is to have unlimited income. So if your account balance exhausts itself during your lifetime and you outlive your account balance, that guarantee continues through your life, the duration of your life. That is appealing to some, and I wouldn't put too much of your net worth into annuities exclusively. It's better to have a diversified portfolio. But if you have enough assets and you say, I want the comfort and security of having unlimited income for the duration of my lifetime, Social Security is not going to be enough. There's a benefit to annuities, but be cautious about the motivations. And you may have a great trust relationship, and that's not a problem. But in a new relationship with an advisor who's trying to sell annuities, be cautious because their commissions are very high commissions on those products, and especially if you're doing a single premium annuity like $100,000, I mean that's a big slug of money for that agent. And not to say that all agents are motivated by that, but let's be real. There's a large population of that going on. So I don't know if that answered your question, but
Thank you. Yeah.
Okay. Any other questions?
Excuse me, could I ask a question?
Sure.
About the long-term care policies in which
Sure.
you're able to stay home and have care within your own home.
Yes.
Are there things to look out specifically for that?
Well, if you're gonna do it, I would clearly do one of those hybrid policies. Again, this just my disclaimer is, this is more of a financial advisor question as far as kind of getting you the right policy. So I want to make that disclosure. But from my perspective, I would do a hybrid policy with a death benefit in the event that you never make a claim. If you're going to use qualified money, if you have an IRA that you want to use as a source of monies for that, there are a few companies that do that well. And I'm not going to mention them on this webinar, but if you're stuck and you want that question answered, you can contact me in my office and I'll tell you who they are. But they're good. That's a good company. It's really a personal decision, and I think everybody wants to be felt secure that their care expenses are paid for, and if you've got the funds to do it, I wouldn't jeopardize the quality of your life to fund a policy, too much. They can get expensive, and like an annuity, these single premium hybrid policies carry a pretty heavy commission. And not to say the commission is bad, but just I want you to get independent advice without that commission influencing the agent who's selling it to you. Just be careful of that.
Thank you.
Yep.
Oops, I dropped the phone. All right, any further questions? Otherwise, the library is closing in a few minutes here, so we need to wrap up. And Sean, thank you so much for
Thank
coming
you.
out.
Thank you
Tri-County
all.
Home Health, thank you for
Appreciate you
making
coming.
this
Yes.
presentation possible here at Phoenixville Library.
Thank you.
All right, thanks folks on Zoom for tuning in tonight, and those of you who've been here in the room.
Thank you.
All right, thanks folks.
Yeah.